Let's do Wiley v. Spratley. There you go. Good. What court wrote this opinion and when?
In 1976, the Supreme Court of Texas.
Who is appealing the case to the Supreme Court of Texas?
The mother.
The mother. Had her rights as a parent been terminated?
Yes.
By the trial court and also?
The Court of Appeals.
Yes. Both lower courts were cutting her off, terminating her rights as a parent. We know you have to satisfy the second prong, is that it was in the best interest of the child. What was the first prong?
Was 1502E under the old family code, now F, and it said that the parent has failed to support the child in accordance with his abilities.
For how long?
A period of 1 year, ending within 6 months of the date of filing.
Do you know what the year's period was that she was found to have failed to support the child?
July 17th, 1973 through July 16th, 1974.
Great. July 1773 through when?
July 16th, 74.
Okay. Now, does the Supreme Court allow that termination to stand?
No.
No. Why not?
They go through the facts and find that she made some payments during that 1 year period.
She made some of these support payments. When the state agency comes in and takes the child from the allegedly improper home and puts them on in foster care, the parent is invited to be involved in a plan and to rehabilitate the parent with good parenting skills. And part of that plan involves payments to the state to reimburse the state for their expenses on the child or actual child support payments. Now, how much were her child support payments?
$33 a month.
$33 a month, and she actually made those payments when?
She made the first one August 6th.
Was that the one that came back with
no,
check bounce on one?
That's
They made that one, okay, in August. And then
she made one for $30 in May 14th, and she made one for $30 July 2nd. But the one in April was a money order, and they never received it.
And what else did she do, if anything?
Oh, she gave the kid gifts throughout the year, or cards, and
Easter, Christmas, birthday, and so on. And the Supreme Court said she didn't fail to support the child for a period of a year. In fact, the present form of the statute is different. How was what we look at here is material change, substantial change in circumstances of whom is what we're looking at here. How was the statute worded at the time this case was decided?
Okay, when that case was decided, it was child or parent.
Child or parent. Who was awarded custody at the time of the divorce here?
Okay, originally, father.
Father was given custody, and now the ex-wife wants to, the mother wants to modify the custody decree so that she is the managing conservator. How did she request to instruct the jury?
Okay, she wanted to include herself, possessory conservatory, in the jury instruction. Child, parent, or mother.
Okay. And here she's the possessory conservator, he's a managing conservator, and she wanted to take the word parent, and that's the language used in the statute, and say, has there been, and we're just talking about the first question of the three questions. The first question is, has there been a material and substantial change in the circumstances of the child, or the managing conservator, or the possessory conservator? And that's what she wanted to do, and then assuming she gets over that hurdle, then you still have to have the second two inquiries, which or no piece of cake, certainly this one, then there would also have to be the finding that to retain the present MC would be injurious to the welfare of the child, and then it would be a positive improvement. And we've seen cases where you have these two and not that one. We saw at least one. Did the court instruct the jury that way?
No.
No.
They left it the way it was. The child parent to the,
Well,
or managing the.
okay. In particular, the trial court says that the use of the word parent here means only managing conservative. And is that decision rationale upheld here by the Texas Supreme Court?
Yes, they said.
Texas Supreme Court agrees. That's the holding. This was a highly criticized case when this came out. In fact, shortly after this case came out, the statute was changed by the legislature, but the Supreme Court holds here squarely that the use of the word parent in the modification statute means only the managing conservative. Now, there was one of the ways that Jones v. Cable was described by the commentators at the time was it was the bottom of the barrel case, and it was if you had the conditions of life here in a barrel, and if the possessory conservator here who lost custody at the original divorce was at the bottom of the barrel, the wife, and if the managing conservator was not much better, but not quite at the bottom, was right there, Jones v. Cable says you couldn't go in and change even if the possessory conservator comes all the way up to the top. Because it puts blinders on the judge. There had to be a change here in the managing conservator or the child.